So we're moving on now to our first COVID issues section. Like I said in the beginning, we've tried to pick out some issues that are not as commonly discussed so that we don't just repeat everything you already know. And so along those lines, I think we pretty much decided not to spend a lot of time talking about the provisions of the FFCRA. If you're like the only person on the planet who doesn't know what that means at this point, then you probably don't have to worry about it before the end of the year when it expires. And because most likely anybody who was had it available to them or was eligible for it has probably used it up by now. I think we're all waiting to see whether or not it's going to be renewed as of the first of the year. I would say there's probably a good chance that that's true, but of course we don't know. So rather than spending the time on the provisions of that, we have some other topics that we thought might be useful to talk about. And I'm not going to go, I think they're listed on what you have as the agenda, but I'm not going to go in any particular order. One of the things I think we would want to talk about are how having remote workers impacts wage and hour issues within your business. And since Josh did our wage and hour presentation earlier, I guess I'm going to turn to him to sort of talk a little bit about the issues he's anticipating with wage and hour for people who are working remotely in terms of reporting and overtime and those kinds of things.
Yeah, so this is an interesting issue that is starting to crop up in Maine and around the country. And for your exempt employees, it's perhaps not as big a problem, but for those of you who have non-exempt employees working from home, there are some potential overtime concerns here going on that you're going to want to be aware of and kind of think about as you're allowing people to do this. Of course, the default rule is that if you suffer or permit an employee to work for you, then you have to pay them for that time. And that even extends to time that you didn't explicitly authorize them to work. So I think the best place to start is either with a work at home policy, if you have one. If not, maybe you want one, or at the least a conversation with employees who will be working from home about what the expectations are. And this is vital with non-exempt employees. So I think you start the conversation saying, look, your workday is 9 to 5 or whatever the case may be. And although you will have a computer at home with access to all of your work stuff, we do not want you working outside of those hours unless you're expressly told otherwise. So I think you need to make the expectations very clear up front so that they know that. You also need to make sure that they are aware that they need to track and record all of the time they spend working for you and that they get that to you in a timely manner so that you can make sure that they're paid for all time work. One interesting wage and hour issue that actually came up earlier this year was what happens if an employee, not exempt, is doing emails and stuff like that from work, from home, excuse me, after hours. Do I have to pay them for that? Well, that depends. If they are emailing you as the employer or you're CC'd on those emails, if you have some reason to know that they are doing this, or in fact you told them to do this, then you're going to have to pay for that time. And even in an incident where you didn't tell them to send that email at 10:30 at night, if it's work related and you have knowledge about it, you need to pay them for that. You can discipline them for working outside of authorized hours, but they need to be paid. What the DOL has clarified is that you're not responsible to pay employees for time that was unauthorized and which you had no reasonable reason to know about. So if they are emailing customers and you haven't heard about it, they haven't recorded that time, they haven't told you about it, then you might be able to escape some wage and hour liability there. But I think the big thing is make expectations very clear up front.
Great, okay. John or Brent, do you have anything you want to add to that?
No, I just have a question, really.
Not allowed.
I don't do that. So if I'm an employer, can I just outright tell the employee, you are not permitted to work after 6 o'clock and we will not pay you for any work after 6 o'clock?
You can tell them that,
But
it won't be enforceable.
if-
So
if
you
if
can
I
give-
know they do and.
Yep. You can give clear directions, do not work after 6 o'clock. If they work after 6 o'clock and you know about it, you need to pay them for that time. You can fire them. You can fire them, you can discipline them, whatever, for breaking your rules, but you still need to pay them for that time, even if it was unauthorized.
And I've been telling people something similar to that as well, that if they violate a policy about working when they're not supposed to be working and not having approved overtime, that they can discipline. I've yet to see it happen.
Well, the other place that comes into play though is the workers' comp, and I'm gonna talk about that in a few minutes, but one of the ways, obviously we're having a lot of issues with remote workers and whether or not things that happen to them while they're at home are work-related or not, and this has long been an issue with telecommuters. And one of the factors we always look at is, was the employee on paid time or not when they were at home getting their coffee and they tripped over the dog or whatever happened. And so having somebody be accountable for a set period of time, and this is when I'm working and this is when I'm not, is actually helpful in defending a potential comp claim as well. All right, so let's change gears for a second, and let me ask you about face masks. So we're all wearing them. We know the governor has given the order that everybody should be wearing them. But what about you haven't, and I'm certain everybody on the call has dealt with this in one way or another, but what happens when you have an employee who doesn't want to wear one and says it's because of a medical situation? John or Brent, do you guys want to take this?
You have to accommodate them if you can.
Ventriloquist. Well done. I'm the dummy here. I agree with that, but I was going to say something in preface. As I read the governor's order, it's not, let me back up a little bit. Until the governor's recent order, my understanding was, at least on the OSHA side, because I did look this up last week before the order, is that OSHA just generally recommended that as the default, employers encourage employees to wear face masks at work. But as I read the governor's order as it applies to Maine, it's that if it's a public setting, which is defined very broadly, people are required to wear the mask. And so, and my colleagues will tell me if I'm wrong here, but if an employee, not for health purposes, but for some other purpose, refuses to wear the mask, they are violating a law of the state of Maine and presumably can be disciplined for that, at least in theory. But I definitely agree that if the reason for not wearing the mask has to do with, for example, they have asthma or COPD or some other condition, then you're in the ADA world of seeking a reasonable accommodation. And you may be also in a position, though, of the direct threat analysis as to whether or not the employee poses a direct threat to himself or others in the workplace, in which case there might not be a reasonable accommodation, but that's where you're at. You have to make an individualized assessment and think it through, in my opinion.
And, oh, go ahead.
There's always an accommodation available, well, not always, but usually there's an accommodation available of remote working if all else fails. Now, that's not appropriate for all employees, but if worse comes to worse, then that it often works.
You can also look at those clear face masks that don't go over somebody's face. You can look at segregating them in the office. There are multiple ways that you can, try to address that situation and keep people safe.
And one thing to be, there's so many things raised by this, it's hard to know where to go first, but one thing in particular is about the nature of the face mask. So as an employer, of course, you have the general duty under OSHA to ensure as safe a workplace as you can. And so we were talking about the CDC's recent, whatever it is, a guidance or something that said that those, what do you call those things?
Vent things?
The what?
Are you talking about the vent? They
The
got?
No, like
N95s?
the thing that you wear, like skiers wear.
Oh, yeah, the buffs.
A buff.
Oh,
That a buff is not effective like a face mask is. And so, you know, in terms of finding a reasonable accommodation, as an employer, you need to be aware, you wouldn't want to make a recommendation to somebody to wear something in the alternative that turns out not to be, you know, effective in preventing the spread. And that's, you know, partially your duty to do.
It's also interesting to note that recently they're saying that face masks do have some protective properties for the wearer as well as for other people. For a long time there, they were saying that face masks are good for protecting other people from you, but did nothing for you. And now they're backing off that and saying that there may be some protective properties and that could impact some analyses.
Now, so now Brent, when you mentioned the governor's order, you said not wearing it would be a violation of law. And I want to talk about that because there's been a lot of stuff in the news. In fact, there's a news article today in which the governor was talking about people still refusing to wear the masks and what that means for an employer. So just to be clear, it's an order, it's an executive order, right? It's not a law. And so the issue comes up with, for me, the first issue is for an employer, it's a matter of best practice, right? So even if you want to argue it's not a law, we don't have to comply with it. What I would not want to be faced with if the CDC were to come in, or OSHA, is to not be able to say we did everything we could have possibly have done to prevent this exposure, right? So I think, you know, when you're talking about, are we going to require them? Are we not going to require them? Is it public spaces? Is it not? I think that's it's got to be part of the analysis, right?
Yeah, and executive orders are enforceable. So it's just unlikely that it would be.
Right. No, I didn't mean, I just meant it's not, I mean, just to clarify, it's not a law as opposed to being an executive order. But the governor did talk today in the newspaper about not putting employees on the front lines to enforce it. And we'll get into that when we talk about policies and workers' comp and stuff.
Henry, we have a question. What if face masks have offensive images or language?
I love it. I'm so glad somebody asked that.
you mean like this one?
Yeah.
Well, okay, so somebody take the offensive issue.
Right?
Well,
I'll take it.
well,
I think
It's fair for him to do.
as a Patriots fan, I do find that offensive, by the way.
Who won?
It depends to an extent on what the offensive stuff is and what setting you're in, but generally speaking, you don't have to allow somebody to come in and violate your general workplace dress policy just because it's on a face mask as opposed to a t-shirt. You know, it might change a little bit if you think it's a MAGA mask and that offends you, and that's what it's offensive, and you're working for a municipality, you know, then it gets a little bit more tricky there to kind of think through what the implications are there. But generally in the private sector, and if it truly is something obscene or graphic or whatever, you don't have to permit that.
The employer can provide a box of paper masks and say, take your mask when you go to work, and that's what you wear.
Well, again, I think it's a matter of clarification for people too, because I had an employer call in a couple of weeks ago when the sort of the pre-election stuff had really heated up, and said, I've got one employee wearing a face mask that said Black Lives Matter, and the very next day another employee came in with a face mask with a Confederate flag on it. So in order to anticipate those kinds of things, you know, you may want to consider just a flat out policy like clothing or whatever else, no images, no words, no any of that stuff, and then you get rid of that problem completely. Because they run the gamut from, I mean, there's pretty much everything on face masks at this point. Yes.
And then another one, what about an employee who has a concealed carry license and legally carries at work? They should not have their face covered. Does that create an exempt status?
Ooh.
Is there
That's an interesting question. So I guess I could take that unless somebody else wants to. It makes me a little uneasy thinking about masked armed people running around. Generally, I'm not aware. If you're a private employer, I'm not aware of any law or requirement that says you have to allow people to conceal carry within your place of business, number one. There is a law that says if they're a concealed carry permit holder, they might have a right to keep their firearm in their locked vehicle out of view,
Right.
which is different, but I don't believe, unless I'm wrong, somebody tell me otherwise, I don't believe you have to allow them in your place of business with that. And like I said, when you couple that with face masks, it becomes an interesting proposition, let's say that.
A lot
But
of
maybe
things have
for-
changed. I mean, a year ago, I wouldn't have considered walking into a bank wearing a mask. And now, they get mad if you don't. So,
Well, but for a municipality, for instance, a sheriff's department, I mean, they would have the ability to carry a concealed weapon. I don't know of any law that addresses a correlation between a concealed weapon and a mask, though. Were they specific about, is that a rule or a requirement?
Yeah,
They weren't specific, so.
So if whoever wrote that wants to clarify, maybe we can try and address it.
we could look it up at lunch.
Yeah.
Do you want me to ask?
Is there more? Yeah.
So somebody has asked, is it considered a reasonable accommodation under ADA if an employee requests to work 100% from home due to COVID-related stress? Doctor has indicated that they need to receive mental health treatment due to COVID stress so that they are completely off, or so that they are out completely on FMLA currently, and the employee has already inquired about working from home 100% of the time upon their return from FMLA leave in January because of COVID stress. Do we have to accommodate this because of ADA?
let me begin the discussion, because in preparation for this, I looked a little bit, and not surprising, the issue of whether or not COVID-related illness or COVID itself is a disability under either the federal ADA, and not to my knowledge that it's been adjudicated at all under Maine Human Rights Act. There, it's a little bit reminiscent, and I'm not comparing the two other than just saying a little reminiscent of when HIV in the 80s, the question was, well, is HIV automatically a disability? And the United States Supreme Court said, no, it's not. Now, since then, under the Maine statute, as you may know, there's just a list of things that automatically qualify as disability, but COVID hasn't made that list yet. So the first question out of the starting gate is this COVID-related stress suffered by this person a disability under the Maine Human Rights Act to begin with? And if it's not, then you don't have to accommodate it. And so it's not on the list. It's, I think, expected to last more than 6 months. Is that the thing? And it affects your life in a bad way. I don't know. The pandemic is going to last. So maybe the answer is this stress-related problem from COVID does amount to a disability, and maybe you do have to start thinking about whether or not there's a reasonable accommodation that wouldn't be an undue burden, that yada, yada, yada.
So I have a couple of things to add to that. I don't know that maybe you need to look at it more broadly and take out COVID and just look at it as an anxiety condition,
Right.
because anxiety
Well, that's
certainly
what
can
that
be a
seems to be.
disability.
Right.
So regardless of the reason for the anxiety, I think I guess the way I would assess that is the anxiety itself a qualifying disability, regardless of what's causing it? And if it is, then I agree, you then have to work toward finding a reasonable accommodation if there is one. Now, one of the things that I wanted us to talk about is this whole issue of telecommuting, because a lot of times before the pandemic hit, employers were well within their rights to refuse requests for people to work from home if there was any reason why they should be in the office, or it was just better to be in the office. And I think my experience was the EEOC was fairly liberal toward employers to say, no, if you say they need to be in the office, then they do. What we've seen, though, is that now that so many people are remote, you have to reevaluate whether that's actually true anymore, right? You guys seeing that too?
Absolutely.
So that if you've allowed somebody to work remotely to benefit you during this COVID thing, to now just come back and say, no, that's not gonna be a reasonable accommodation. The EEOC has actually published some stuff saying we frown on that. So my answer to this person would be, when the FMLA ends, number one, does it renew as of the first of the year? And you'll have to deal with that situation, or is it a rolling method? And number two, if it doesn't renew, I do think you have to go through the reasonable accommodation analysis, but I think you'd be entitled to information from their doctor about the nature of the disability and why the necessity to be at home, which seems fairly obvious.
Yeah. Can I ask a hypothetical and see what everybody thinks about it? This is a situation I've come across, and I'm sure others have too. What happens if, let's say, we have an employee who has some underlying medical condition, COPD or something along those lines, and they have, let's assume that they really can't work from home. Because of the nature of their position, they are just not able to work remotely. And they get a note from their doctor saying, this employee, because of the risks that they would, because of their underlying health condition, the risk that they might get severe implications from COVID-19, they just cannot go to work until the pandemic is over. How do we analyze that?
Did you want to go?
Well, I mean, certainly under the old standard FMLA, that's not going to be very helpful, but under the regulations that are in place at the end of the year, I think then they are going to be entitled to FMLA leave. You're looking at me. You've got that look.
You mean FMLA? Are you talking about the EPL leave or
No, no.
FMLA or ADA? I don't know if I'm maybe
All right.
I misheard you.
I was talking about FMLA.
Okay. All right.
But after the first of the year, we don't know what's going to happen with that. If a person's out of work for a COVID-related concern, even though they don't actually have it, the question is the current FMLA standards going to allow them to take FMLA time for that?
You mean the FMLA under the FFCRA?
Yes.
Okay. Yeah, I mean, I agree. That's certainly part of the analysis. I guess one of the things that concerns me about the state of the world and what employers are doing is, the first place I would start with that employer is, what are they actually doing for a job? Because a lot of people aren't doing what they used to do. And if their job duties have changed to the point where maybe now they could be accommodated, then that's an issue. But if you've got somebody who's got major performance problems and tardinesses, and I mean, I think you're within your rights to deny an accommodation if you can show that there are objective reasons why. On the other hand, I mean, I don't know, everything seems so broad that maybe you don't have to try it and give them an opportunity.
Let me add this to the hypothetical, which to my knowledge, we did not.
We just made it up.
Just made up.
So the person has COPD, which in my mind is a disability under federal and state law pretty easily. Significant breathing problems. And their request for accommodation is, I just want leave until a vaccine or the end of the pandemic.
Yeah.
And I've been reading articles that say that maybe vaccine by April or something like that. So employer, that is what I want, is a reasonable accommodation. What sayeth you? Depends, I guess, on the what the employee does, size of the employer, hardship to the employer, et cetera, et cetera.
Yeah.
But it's not an actual disability that would be preventing the person from working. It's a potential exposure. So there is no, the request for accommodation is not based on an existing
So you're saying that person with COPD whose doctor says it's too big of a risk to be there, who's not performing the essential functions of the job, it's not really because of it. It's not because of the disability.
No, it's because of the concern of something else happening. I mean, it's really no different. That person may be more at risk, but other employees have a risk of coming down with the illness and getting very sick as well. So it's just a matter of degree. But right now, sitting before you, they have no condition.
I actually think the DOL or the EEOC has issued an opinion consistent with what you just said, which is that fear of getting something is not the same thing as having a disability. Unless it's
So maybe the moral of the story is to call us if that happens.
And we'll debate it.
Well, I
Oh,
think,
all right, 5 minutes. Okay.
my gut's telling me a little different, but that's why we're here.
All right, so what I'm gonna do is I'm gonna leave workers' comp for the next one, and I just wanna ask my fellow panelists about this whole social media thing, because I know that you're dealing with it. And by that, I mean, what does an employer do when all of a sudden they get 25 or 40 emails in a morning saying, I saw a so-and-so employee at the rally for whoever was here, and there's a picture of them in the paper and they're not wearing a mask. Does an employer have to, what do? They have to do anything?
Well, I'll say something.
Please
Um,
do.
as much as it pains me, I don't think that there's enough evidence and knowledge to support it, the idea that just because somebody was in rallies politically, but whatever it was, wherever they were, in a group of people without a mask, I don't think that's enough to support the idea that they're really posing a significant risk to fellow employees.
But what if that
Yeah.
action violates one of the governor's current orders? You and I talked about this.
Well, then-
Employer policy.
Or, right,
Or an employer policy, well, or the order, then I think they can be disciplined. Because I do think executive orders, I think we get tripped up on what's a law, what's not a law. It definitely has the force of law, whatever, and I think there may well be some interesting academic, maybe they're already being written right now as to what exactly are executive orders, but they are enforceable by the full weight of the administrative structure, the agency structure in the state. So,
But I don't think it's necessarily discipline. If you're telling this person, you now have to work remotely if you can for 2 weeks, it's not necessarily disciplinary action taken against the person. It could be a reasonable direction to the employee.
although it could be, right? I mean, if you've got somebody out there who's purposely violating an order that's in place, and now you've got employees saying, why should I have to work around somebody who's violating an order and potentially putting all of us at risk? Couldn't that be grounds for?
I think it
discipline?
could be as well, but it doesn't have to be. If you're asking this person who has no symptoms, but has been seen out in public without a mask to now work from home for 2 weeks, there's nothing necessarily disciplinary about that. You could just say, just go home and work.
but it's hard, and maybe I'm just not seeing it though. What law would the employer be violating in terms of that employee's rights if the employer said, no, you guys stay home?
And that's your
For a
public
couple
sector.
days.
I agree. Public sector might have other issues, but constitutional.
And of course, assuming, of course, that you're not just doing it for women or,
Uh-huh.
Yeah.
So
or
that's the next thing.
this or
Somebody
that
goes
or
to the
whatever.
Trump rally and you do that, and then somebody goes to a rally for the Girl Scouts
Yeah.
and you don't do it, what happens then?
Well, private employer though can, which you almost would never do for any, but it's not a protected category, Republican, Democrat, Libertarian, right? I can fire somebody for being a Libertarian
Is that necessarily gonna prevent
or
someone
a
from bringing a
socialist or
suit?
whatever. Well, I just,
No.
I would say the best practice would be to make sure that you're applying that rule consistently,
That's
regardless of why the
Yeah.
person is out in public doing
Right.
these things. If they're not following the rules and regulations from Governor Mills or whatever, treat them all the same.
always a good.
Excellent advice.
And the question on that is, even if the person in this example is not on the clock or company property?
Doesn't matter.
Doesn't matter.
I think especially in this extreme situation.
Yeah.
But again, as you're amending your policies, which we're going to talk about in the next session, you may want to consider talking about off-duty conduct, which maybe you've never, tried to mandate before. So I think with that, we are at the end of our time for this session.